Deal, Flathead, Sadeq, and Dechert LLP and others.
Yes, Ms. Oppenheimer. We've obviously received the abbreviated note. Understand correctly, this is what you would, having had regard to our observations yesterday, what you want to proceed on.
Well, it's to give you an option, but given your indications, we obviously haven't heard what my learned friend has to say. If he's content for us to submit that one to your lordships, then I'm not going to press the longer version.
I think our view, having not read the longer version in detail, but had a better idea of the kind of document it is, I don't think it's going to be helpful to us. This document will be, I'm sure, as a form of roadmap to your oral submissions. I gather you're not simply going to hand it to us and move on to something else. You're going to give us the key points on the evidence and take us to the key documents. Is that right?
Well, I will be taking you to a few documents to give you some more examples that you asked me to do yesterday, but I'm not going to have time to take you to the key pieces of evidence.
Very well. We will obviously we will use this document in our preparation of any of our judgments so far as necessary. But I think we were expecting to have some submissions on the evidence. I appreciate you couldn't spend all your time on them, but it would be helpful to us to know which are the key documents you think will particularly assist us. There's a lot of material here. And as I say, I'd rather assumed you were going to be saying, walking us through it, saying you see what my submission is here, and here is our best document on that point, and read the rest later. But that's not what you're
I don't think I'm going to be able to spend that time. I have until, if I allow myself half an hour for my reply tomorrow, I have until, I think, 3 o'clock. I need to deal with a bit more law on the crime fraud exception. There's quite a lot to address you on litigation privilege, and I also need to deal with legal advice privilege. So I hear what I will do my best, but I've had to have regard to what I've still got to cover. There's quite a lot of law still to cover.
Well, Mr. Eadie, you haven't got to persuade us about the longer documents. You've heard what I've got to say about the shorter document. You've heard what Ms. Oppenheimer has to say about how she proposes to deploy it. What do you have to say?
I can read the room in the sense that the 6 pages, my lord clearly regards as less egregious, which in terms of page plainly is. It has to be said that there's a lengthy skeleton from the appellant. There's then a skeleton in the context of the further evidence explaining the relevance of those documents, yes, allegedly to the, and then a supplementary skeleton. They've then asked for more time. We've now got 2.5 days. I've given my learned friend more time orally than I'm getting orally.
Well, that last point is not a good point, because inevitably the person opening the appeal needs a bit more time overall.
But the consequence of this is I have prepared my submissions on the basis that I expected this to be an oral exercise, that I would take my lords to the relevant oral documents that I thought my lords would need to listen to. That obviously takes time away from the other things I might have spent time on if I'd been putting in a written document. I'm not asking to shut it out. I will take my course. I've tailored my submissions on the basis I've got the time I have, and I will deal with facts as I can in the time available.
Well, let's. I'm just going to have a word with my lords. I think we'll just rise for a short time.
Can I just say one thing before you do? I'm not asking, I should say, for the opportunity for us to put more things in writing. I have professional commitments which will make that very difficult in the run-up to Christmas and indeed in the New Year. I've got a terrific team next to me and behind me. But again, we say it's not really fair for them to be expected to put something in writing at this time of the year. So I'm asking for that opportunity.
Well, thank you for making that clear. We'll bear that in mind, but in fact, yes, all right. Well, just take a rise for 2 minutes, I think.
Got rise?
Yes, well, very well, Ms. Oppenheimer. You're obviously in charge of your own submissions, and will allow you to proceed as you wish. You're clearly concerned about time. We're prepared to say exactly how this plays out as between the time for the two of you, but we will at least sit till 4:30. I think you'd assumed we'd be rising at 4:15, so that just gives a little bit of elbow room. And one point that at some point we would like you to just address, it needn't be now, it may well come up in the course of your submissions this morning anyway, is the question of who exactly is the client in this case.
Very well. And when I do come to the note, I will endeavour to at least highlight for you on that the list of references.
Well, that would be helpful. Thank you.
My Lords, can I deal first with the points that were raised by my Lord Justice Popplewell about the strong prima facie case at the end of yesterday? In our submission, we think that the following 4 questions arise. First of all, is it open to us to invite this court to depart from the strong prima facie case standard? And if it is open for us to do so, do we ask the court to depart from that? Second, if this is a question which the court can consider, does the strong prima facie case standard reflect the law? 3, is the distinction drawn by Lord Justice Longmore and Q8 Airways between cases where the allegation of fraud is in issue on the pleadings and cases where it is freestanding and independent, is that distinction an appropriate one to draw? And 4th, what does either the strong prima facie case mean or to the extent relevant, the prima facie case mean? So on the first point, my Lords, as my Lord Justice Popplewell noted, we did argue below that the prima facie threshold was the appropriate one in the circumstances of this case. And the argument we made below was, in summary, that there are 2 suggested rationales in the authorities in support of the application for the higher, strong prima facie case standard, neither of which we said applied to this case. The first rationale is that the risk of unfairness to the defendant if the prima facie case turns out to be unfounded, and that's Lord Justice Longmore's point in Q8, that risk arises particularly where the prima facie case reflects some issue in the action. And we said that concern didn't arise because here, whilst the issue of fraud is relevant to the action, it wasn't determinative of the defendant's liability. The second rationale was that in some cases, ordering disclosure applying the exception would give rise to a risk of unfairness because the disclosure might encompass documents concerning the defendant's defence of the action. And that's a rationale articulated in Chandler and Church we did cite below. And again, we said that didn't apply in the instant case. And for those reasons, the prima facie case standard was the appropriate one. Now, the judge didn't resolve that issue, given his findings that we failed on limb 2 of the test. And he therefore held it was unnecessary for him to decide the issue, although he indicated, as you know, that he would have concluded that the strong prima facie case standard was the appropriate one, given the overlap with the issues in the action. Now, my lords, on this appeal, we haven't sought to challenge that. I think it's an obiter conclusion, have proceeded on the basis that the strong prima facie threshold is the one that needs to be met. Now, it may be that, strictly speaking, in circumstances where that conclusion was obiter, it may be that we don't need to challenge it as a specific ground of appeal, but obviously we have expressly addressed the judge's other obiter conclusion on iniquity, and that is that strong prima facie case standard wasn't met, and we've obviously dealt with that extensively in our grounds of appeal and skeleton argument. So, my lords, not having included the point in our grounds of appeal, and therefore it not having been addressed in the parties' skeleton arguments, we don't think it would be appropriate for us to do so now, and indeed I think my learned friend might reasonably say it's not appropriate or fair for us to seek to amend our grounds of appeal at this stage. That said, we are mindful of what my lords have said about the need for this court to give appropriate guidance as to how the exception is to apply, so that it will be of assistance in other cases, so that even if it was an obiter finding here, that obiter finding of the judge isn't part of our appeal, I will endeavour, with your lordship's indulgence, to assist the court on the questions raised. So that takes us to question 2. If this is a question which the court can or will consider, does the strong prima facie case standard reflect the law? And my lord, having considered the authorities again overnight, in our submission, and in particular having regard to O'Rourke and Derbyshire, it is doubtful that the strong prima facie case standard properly reflects the law. I think, as my Lord Justice Popplewell observed, O'Rourke and Derbyshire was a case in which the allegation of fraud was an issue in the action, yet all of their lordships expressed the test by reference to a prima facie case only. And again, looking again at Q8, it may be that Lord Justice Longmore's consideration of the standard may have been obiter, given that it didn't actually matter in that case, because the fraud had actually been established through a decision in prior proceedings. My lord, I will finally, let's go to O'Rourke and Derbyshire to look at these points on the prima facie case, but also I'm going to draw your attention to all the relevant passages that are relevant as well for the breadth of the test. So looking for the prima facie case point, the breadth of the test, and also the sort of third basis on which this decision is very important, is that it supports our proposition as to the whole range of evidence that an iniquity applicant can use to establish their case. It will all depend on the circumstances of the particular case. So, my lords, it's at tab 2 of the authorities. Tab 4, thank you very much. Tab 4 of the authorities bundle. And if you need a reference for for why the fraud is an issue in the action, you can see some extracts from the pleadings at paragraphs 59 and 60. Halfway down on 60, you see paragraph 12 of the particulars of claim, making reference to a fraudulent scheme. If we then turn to the speeches, firstly to Viscount Finlay, one starts at page 79. And I'll leave your Lordships to read not just the sideline passage, but really down to the end of the page, just before the final paragraph. And just before you do that, you'll see he expresses the test by reference to prima facie case. You'll also see in this passage a reference to the court exercising its discretion. I'm going to come back to that in answering my Lord Popplewell's point about whether there's some sort of balancing discretion act that needs to go on. I'll come back to that, but just so that you note, if you wouldn't mind just reading the majority of that page.
Yes.
If we could then turn, my lords, to Lord Sumner.
It's just perhaps worth pointing out
Yes.
the phrase prima facie case is just one of a constellation of different phrases that's talking about giving some colour to the charge.
Yes.
It's presented, as you say, as a discretionary exercise, and the phrase sufficient probability of its truth to make it right to disallow the privilege.
Yes.
Thank you. Sorry, we'd all seen that, I'm sure. But
and the expression prima facie at one point applied to prima facie evidence.
yes.
And later to a prima facie case. Maybe actually a different concept.
Yes. I'll come back to that when I deal with the fourth question of what that all means. If you would mind now turning to Lord Sumner's speech, if you go to page 88. And there again, he refers to the test by reference to the prima facie case, and the wording we've already referred to in the skeletons, and I draw your attention to about being brought into existence in the course of. If you read from subparagraph 1 down to the that passage that's sidelined.
Yes.
Then over the page, my lords, if again the sideline passages, again reference to prima facie.
So you said passages. It's
Sorry,
one passage.
the sidelined passage.
Yep.
You see again reference to prima facie case, and also again the sort of evidence that one could bring forward to make out that case. Evidence, admission, inference from circumstances.
Yes. Although the phrase prima facie case is used, it's all rather qualified, a sufficient prima facie case for this purpose, and talks about weighing the materials.
Yes. Then we move to Lord Parmore, page 96. Again, it's the passages that we have sidelined from 96 and 97, again you'll see reference to the prima facie case, if I can leave you to read those.
Yes.
And then again over the page to 98, continuing Lord Parmore, the sideline passage about, again, the kind of material that can be brought forward to make good the prima facie case.
Yeah.
And then we move to Lord Rembury. We start just at the bottom of 107. Sorry, page 106, apologies. We start at the bottom of page 106. He records the plaintiff invoking the crime fraud exception and then refers to the Queen and Bullivant. And then if you read from there over the page, I'm afraid that's not sidelined, but down to about 2/3 down the next page.
Yes.
And then 108, the sideline passage is where Lord Renbury gives his, as it were, analysis of Bullivant, and that's the sideline passage, if you could read that.
Yes.
And we rely in particular, my lords, there about this may be done in various ways, pleading admissions, which go to show fraud, affidavits, possibly even without admission. So we do rely on some of the non-admissions, as you'll have seen from our skeleton argument. So, my lords, that I think is all I need to show you in O'Rourke. Q8 Airways, unless you would...
What was the actual decision on this point in O'Rourke? Were the documents disclosable because they fell within the exception, or were they not disclosable because there was only an allegation in the pleading? Just trying to work it out, I can't see it.
It's the latter.
Yes, so it's a decision that a pleading, just a mere allegation, is not enough because that's all there was.
Yes.
But it doesn't actually need to define precisely what the test is for disclosure. Is that fair?
Yes, I think that's fair.
And there are also dicta on that it doesn't answer the question that the pleading hadn't been struck out.
Yeah. We saw that.
So it's some higher test than that.
My lords, Q8, I wasn't, if you find it helpful, I can take you to it, but I was just going to make the point that you can see from paragraph 39 of that judgment that Lord Justice Longmore found that there was even more than a strong prima facie case found. The fraud had actually been established, and on that basis, the passage at paragraph 42, which is always cited in support of this proposition of the strong prima facie case, I think there's a basis for saying that that is obiter. Now, there are obviously first instance judgments in which the test of strong prima facie case has been applied. We are not aware, however, of any in which the status of the statements in Q8 have been the subject of argument. So neither in my Lord Lord Justice Popplewell's judgment in Obliazov. It was applied in Group 7, in Barrifan, and in Barclays and Eustace, but there was never a discussion about that passage in Q8. My lords, the other point to add is that we think that the earliest reference to a strong prima facie case, or the earliest one we've been able to identify, is in Darby and Weldon. That's in your authorities bundle, tab 13, page 271. And it isn't really put as a test, but Mr. Justice Weinlott expresses his conclusion on the basis that the plaintiffs have established a strong prima facie case of fraud. But it doesn't seem that that was a test he was applying as opposed to just the conclusion he reached on the facts. And as you know, that is the case that is cited for the proposition that there is a continuous spectrum. That's at page 270 of the report. It's not possible to express in a simple formula the strength of the case required. So that's the points 1 and 2. The third is the distinction drawn by Lord Justice Longmore in Q8 that I've already identified, is that an appropriate one? And we respectfully share my Lord Justice Popplewell's concern about that justification. As a preliminary matter, it is doubtful whether there will be many cases in which the relevant issue of fraud is not at all an issue in the action, because otherwise it's unlikely that disclosure would be sought of documents which are part of that fraud. But aside from that, it's not clear to us why it would necessarily be unfair to a defendant to order disclosure based on only a prima facie case, simply because the fraud is an issue in the action that might turn out not to be established. And we say that because the prejudice must be limited in circumstances where the defendant has gone on to win the action despite the disclosure. And secondly, it is in some extent an unavoidable consequence of having to make determinations on an interlocutory basis. However, we can see the concern about ordering disclosure where the documents don't concern a past transaction, but an allegation of iniquity is made in the course of defending the claim. And that, I think, is a point that my Lord Justice Popplewell alluded to in his musings at the end of yesterday's hearing. And we can see that in that case, the defendant may suffer real prejudice if his privileged communications concerning the preparation of his defence are required to be disclosed. However, that risk obviously arises not because the allegation of fraud is an issue in the action. It arises because the allegation of fraud concerns the conduct of the action.
Well, I know I'm responsible for this, but is that really a relevant distinction? I mean, we're looking at an iniquity exception, which invades both transactional advice as well as the pursuit of the conduct of litigation. And the underlying rationale for preserving privilege in both cases is essentially to promote the efficacy of the legal services being provided, both for that individual client in the instant case and more generally for others, so that the rule has the public policy effects in both directions. That applies equally to transactional advice given by a solicitor outside the course of litigation as it does to the conduct of proceedings, doesn't it?
It does, my lord, but I can see that there might be a basis for some uncertainty in cases where charges of an allegation of fraud is being defended, and the whole purpose of the instruction of the solicitors is to assist in making the best case possible. I think name now escapes me of a more recent case on the crime fraud exception. I'll come back to it, but where a distinction, again citing the Obliazov criterion, the distinction is made about there is a judgment to be made about whether in defending a claim to fraud, the solicitors are part of concocting something very serious that could be fall within the abuse of the solicitor-client relationship, or whether it is simply putting forward a case to those charges. I think I can see that there might be cases where litigants are in a more invidious position because it may be harder to draw the line than in a transaction case. I'm sorry I can't now recall the name of the case, but I'll refer my lords to it later when I do. Can I deal with the fourth question, my lords, which is what does the strong prima facie case mean, and to the extent relevant, what does a prima facie case mean? There obviously isn't any very specific guidance on this in the authorities, particularly on strong prima facie case, because of course O'Rourke and Derbyshire is all about a prima facie case. But approaching the matter from first principles, we submit that it cannot require, in either the strong or the prima facie case, cannot require an applicant to establish the fraud to a level of confidence greater than 50%. That wouldn't be a strong prima facie case, that would be proof. Equally, if the strong prima facie case is an appropriate one, then we accept there must be something a bit more than a prima facie case. And we would suggest the strong prima facie case must be something which equates with a case of a real prospect of a success. And we would suggest that in applying, and I'll explain the distinction one I could offer in between the prima facie and the strong prima facie test, but we would suggest that the type of exercise the court needs to carry out in either case will be along the following lines. For the court to consider, on the basis of the materials available to it, which party has the better of the argument in relation to the issues of fraud. So the court is assessing the relative strength of the parties' cases on the basis of the evidence before it. Obviously, that's a conclusion on a prima facie basis only, because it's reached on the basis of available evidence and could change at trial. We suggest the difference between the two standards might be that a prima facie case is simply satisfying the court that the applicant has the better of the argument, and perhaps a strong prima facie case establishing a much the better of the argument. And that it isn't just an invention of my own. If you look at the Barafin case and what the deputy judge said there, he concluded, having regard to Derby and Weldon, that a very strong prima facie case required him to be satisfied that the threshold is comfortably exceeded, and the case is one which falls at the very end of the continuous spectrum. That's paragraph 40 of the Barafin decision.
But the better of the argument, or much the better of the argument, it reflects quite a lot of developed jurisprudence on what good arguable case means for the gateway jurisdiction cases,
Yes.
in which at least we've got the guidance of Lord Sumption in Brownlee and Four Seasons as to how that might be applied in practice to evidence and tests of plausibility and so on. But your submission is it that prima facie case means the better of the argument, which is, I think, where the jurisprudence has settled on the gateway cases, and strong prima facie case means much the better of the argument, which was the Canada Trust and Stoltenberg loss.
Took about 15 years of litigation to get rid of the word much in that context.
Just to complete this point, can I just address the other point that my Lord Justice Popplewell raised about whether the standard should involve some elements of balance of harm? And I did note that passage in Viscount Finley's speech in O'Rourke about when he uses the language of discretion. We would, however, respectfully contend for an approach where the court adopts a flexible attitude towards how that evidential threshold may be surpassed, rather than regarding the question of whether disclosure is to be ordered as involving a balance of harms or an element of discretion. And we say that because it seems to us that it would generally be difficult for the court in conducting a weighing exercise. Typically, the court will not have much of a sense of the nature and importance of the documents over which disclosure is sought. obviously, because they've been withheld. So we would say we would distinguish how the test should apply here from situations in which provisional assessments are made concerning a balance of harm, such as the freezing order and injunction type jurisdictions, where the consequences of not making the order are much clearer.
But when you suggest, respectfully, that there should be a flexible approach,
Yes.
how does the merits come into a flexible approach? We've been discussing what the test should be for a threshold. Where's the flexibility?
Well, it's in what Mr. Justice Weinlott said in Derby and Weldon, which is it's a spectrum, and I think what comes out quite strongly from O'Rourke and Cox and Railton is that it's going to be a matter for the appreciation of the judge whether or not the threshold is met on the facts of the case.
I mean, one way in which one might introduce flexibility is to say there are two stages. There's the threshold stage, let's say good arguable case for the time being, but by analogy with the position in interlocutory injunctions generally, where you have a case in that context where the so-called interim injunction is in fact going to be finally dispositive of the rights of the parties, then the NWL and Woods line of authority says you do take it into account, the merits, when you come to the subsequent stage of the balance of harm, the balance of prejudice. And certainly in Ablyazov, I thought there was a discretionary stage, even once you've got through the iniquity gateway as to exactly what you order, and indeed in that case whether to order anything in particular circumstances of that case. And certainly one way of addressing flexibility would be for the flexibility to come in at that stage.
Yes, I can see that, my lord, the discretionary element, and simply my point was that that discretion shouldn't come into the stage of the prima facie case. Can I just finish with one point? I don't need to take you to it, but the Queen and Gibbons, which I did take you to yesterday at paragraph 50, page 470 of the bundle, I'd invite the court to note the approach that was taken by the Court of Appeal there, where they said they didn't think that any gloss upon the requirement of a prima facie case is desirable. So that perhaps takes us to where we started with my Lord Justice Popplewell's question.
Yes, and that was a judgment in which the question as to whether it should be strong prima facie case or prima facie case was quite specifically addressed over a number of paragraphs.
Yeah. My Lord, I hope that's been of some assistance. Can I come to...
Yes, thank you, Ms. Appellant. That must have required a bit of work by one or both of you overnight, and we're grateful for that help.
Can I just deal with one more query of my Lord, the Vice President? You queried yesterday whether we could ascertain in Butler and Board of Trade where Mr. Justice Goff got his tripartite distinction.
Yes.
We checked. There doesn't seem to be anything specific in the judgment, as I'm sure you saw. But our working assumption is that it's a reflection of the O'Rourke and Derbyshire formulation of brought into existence in the course of. We haven't found the distinction.
No, well, that's helpful. I just wondered whether, because it was, as I say, he'd obviously fastened on it
Yes.
as a phrase he was going to use. He used it 3 times,
Yes.
but it may well be his own coinage. Thank you.
Thank you. Finally, on the authorities of Lyazov, which is in the third authorities bundle behind tab 32. The bank applied here for disclosure of documents by 3 firms of solicitors who'd acted for Mr. Appellant, contending that they fell within the iniquity exception. In my submission, my Lord Justice Popplewell's approach in that case involved considering, this is back to how you approach the first and second stage, but your approach involved considering whether the iniquity touched upon the relationship with each of the 3 firms of solicitors, and whether those solicitors were retained to further the iniquitous strategy. So you obviously had to consider first what the strategy was, and Lim 2 could only be answered by reference to Lim 1. just to make that good, if I page 784, sorry, 782, page 64 of the judgment, there's a reference there to the implementation of the strategy from which the court is asked to infer the solicitors will attempt to further it. So that's what I just wanted to observe about the approach. Excuse me.
No need to literally, just give me the page reference again.
782,
Thank you.
para 64. If we can then move to the passage that everybody cites, and indeed we've both referred to in this appeal, is on page 792, paragraph 93, the as of touchstone.
Yes.
And then paragraph 98, page 794, again sideline, where my lord makes the conclusion from the evidence, again starting with the iniquity and the strategy that Mr. Ablyasov was found to have employed, and that then gave rise to a strong inference that the advice was sought from the start in order to assist in fashioning and pursuing such strategy. Get that at E to F.
Yes.
And then the following paragraph, the role of the solicitor obviously may be unwittingly involved in the fraud. If you could just read that paragraph.
Yes.
And then could I just draw attention to that final sentence in that paragraph? I note it's one which brings relevant communications within the iniquity exception. Again, I just...
So which paragraph, 99?
Yes, sorry, my lord, at the end of 99. Just
Yes.
again, you'll recall I
Yes,
noted
sorry.
that in Butler and Board of Trade, Mr. Justice Goff said that often relevance and furtherance of may merge and give rise to the same result. We'll come on to say that to see then the communications which were then found to be captured, and that's just below at 102 and 103.
Yes.
So it was obviously accepted that there were some communications that would not be captured and would need to be carved out. And then if you could read paragraphs 104 and 105, again in my submission showing that the in furtherance of is to be interpreted broadly.
Yes.
My lord, I think that
So it's apparent that I thought then, paragraph 103,
yes.
that the relationship test extended to documents revealing the iniquity. And that's why I made the order in the terms of subparagraph 3, draft order being set out at paragraph 2.
Yes.
Judgment, documents which contain information about the assets. But I don't now remember whether that was an aspect of the scope of the order, which was the subject matter of any argument or discussion.
Yes. There's one other passage there. Yes, the only other point connected to that of my lords is in 104, towards the end of 104, the last sentence, you refer to communications containing such information were made as a result of the iniquitous strategy. So again, the broad application of the test.
Yes.
That was all I was going to say on the law. Then wanted to turn to the evidence.
Yes.
Well, it's just preliminary observation. We would say that there are two reasons why you should be less hesitant to interfere with the conclusion of an assessment of the facts in the nature, given the nature of this case, than would ordinarily otherwise be the case. Two reasons for that. The first is the judge did not conduct any analysis of the extensive evidence relied on by Mr. Sadeq below. He simply said that he would have accepted the respondents' submissions, which were in fact themselves brief and didn't grapple with much of that evidence. And the judgment simply contains no independent evaluation of the evidence by the judge. So we say that doesn't give rise to a significant degree of appellate restraint. The second reason is it's well established that in cases involving delayed judgments, it is appropriate for the court to look more critically at the judge's reasoning than would ordinarily be the case. That's our skeleton, paragraph 101, core bundle, page 73.
We haven't asked, and the party hasn't made a point about it. But hard not to know, hard not to be concerned. There was a period when the judge was ill, but apart from that, that was apparently a very specific period, you will offer no explanation of the reasons for the delay.
No, we won't.
No, thank you.
So, my lords, I'm going to do my best to try and highlight from my notes, and I do want to focus on the examples because I think that is going to be most helpful to you.
Yes.
But can I just explain how I would have dealt with this with a bit more time? There's effectively, if you like, three parts to the submissions on the evidence. The first is that Mr. Sadeq relied below and relies here on a number of strands of evidence, and those strands are set out in our appeal skeleton.
Yeah, we can find them there. Yep.
Yes. There are then various of those strands which apply to all three types of iniquity. So the first section of this note is giving you reference to all of those that are relevant to all three. And then the note goes on to consider each of the iniquities in turn and what we rely on specifically for each of those. Now, much of what you need, you can get from Mr. Chatterley's statements, because he and I apologise for my longer note, but a lot of that was simply bringing into one place things that Mr. Chatterley had said. And so
and indeed, also presumably, I say presumably, I know, so I read it, from the skeleton argument. I mean,
yes.
Most of this material is there.
It is. It was extremely condensed in the skeleton because,
yes.
We had the 45-page limit. So this may appear more daunting than it is. I think you from the first sections, for example, you can simply read Mr. Chatterley's sixth witness statement, and it contains all the relevant extracts. If you'd like me to highlight some of these ones that we particularly rely on under number 4, the background of human rights abuses, probably the most important one, or two, on A, the first report, which talks about secret detention by the ruler, and H, Miss Rada Sterling's report.
Thank you.
The letters, again, they're all summarised in Mr. Chatterley's witness statement, but we'd highlight in particular the first one in that list. Evidence that Mr. Sadeq's treatment formed part of the investigation. Now, this material was all before the court. It hasn't been gathered together in a place like this before, and we did in this note because of the point taken against us that, well, it's never been part of your case, that Mr. Al-Sadeq's treatment formed part of the investigation, or that the ruler was responsible for it. So that is what we have sought in this section, is to give you all the references on that. And in fact, under A, the ruler as a representative of Dechert's client, we would say goes to one of the questions my lord raised at the beginning about who is the client here. We say it's clear that at least one of the emanations of the client was the ruler himself. As for the documents to highlight to you, under subparagraph A, the ruler as a representative, we'd say in particular 1 and 2. The second engagement letter is addressed to the ruler. On Mr. Al-Sadeq's letters, again, it's the 5th of September one, which is the one I referred you to earlier, that we'd say is particularly important. On Dechert's notes of interviews, the first one in the list there, Mr. Gerard says that the release is conditional, that Mr. Al-Sadeq's release is conditional on his cooperation. Under the internal Dechert and Al-Tamimi emails, those are the local lawyers that Dechert engaged, it's in particular the first document there that we'd ask you to look at. I will come back to that in the case of the examples.
Sorry, it is very helpful, but E1 is this?
E1, yes. I'm actually, when I come to give you an example, I'm going to come to that anyway. F, the draft settlement agreement, that we would ask you to look at, because it reveals that the ruler's pardon prior to judgment, the ruler's pardon being given, depended on Mr. Al-Sadeq giving full cooperation. And then G, the note of Mr. Hughes' meeting, there we'd refer to there. That's the one that I took you to yesterday in a different context, but it makes clear that Mr. Al-Sadeq is to be imprisoned if he or his wife talks to the press about his treatment. And then the further evidence, you have our skeleton on that and the references there. But so far as the specific documents which corroborate Mr. Al-Sadeq's allegations of mistreatment, they're the ones that my lord, the Vice President, may recall. For example, the one about keeping him under hermetic control. You may remember that. Those are the Project Beach reports, and then the special report on Dr. Massad's activities in Iran. So, my lords, then moving through to the specific categories, you'll see the summaries of the pleaded cases are all set out in Mr. Chatterley's 6th witness statement, so you should get everything you need from that. As for the specific evidence, we'd refer you to Mr. Al-Haddad's 2nd and 3rd witness statements.
Well, before you get there,
yes,
the statement of truth on the pleaded case is
yes.
itself Mr. Al-Sadeq's own evidence, isn't it?
Yes, yes, it is. Mr. Paul has reminded me that Mr. Chatterley actually signed it, because Mr.
He did, but he said in signing it,
yes.
I believe this to be true on the basis of what I've been told by the claimant, or some such wording.
Yes. So I'm on the iniquity 1. So Mr. Al-Haddad's witness statements we'd highlight. Of the various documents that listed at 13, we would refer in particular to E, the note of the meeting between Mr. Gerard and Miss Black with the PR firm Bell Pottinger, which refers to Mr. Gerard having no access to legal advice and not charged. And then the strong prima facie case that documents exist, which are part of, we would refer in particular to Miss Black's redacted note.
B1.
Yes, B1, well in fact all of those, B1, B2 and B3. 3. I'm actually going to take you, I'm working off 2 documents. I actually want to now take you, and this may be more helpful and save you time, to those documents, B1 and B2, because we say here are some examples of where we say it's obvious the test has been applied too narrowly. So if you wouldn't mind taking up the redacted list of Miss Black, supplementary bundle 2, tab 15. Just everything is redacted. You'll see at page 310, other than her manuscript note. We say it's likely, very likely, that sentence didn't occur in isolation.
So very likely that what did occur in isolation?
That this statement, and then moves on to something else, that there are going to have been further communications about Mr. Al-Sadeq's detention and its implications for the investigation over which privilege has been claimed.
Was there a date on that we can attach to it? Was attached to it?
I think that'll be in Mr. Chatterley's
Mr. Paul is telling
5th of September.
Which year? Sorry, I ought to have it in my head.
2014.
Sorry?
2014.
Thank you.
I suppose you would say shipped is quite an interesting word when applied to a human being.
Yes. If you then turn over to the next tab, you have the note of Mr. Gerard's interview with Mr. Al-Sadeq on the 9th of September. And you'll see that Mr. Gerard states that he's going to take away the information that Mr. Al-Sadeq has provided.
So, sorry, which page are we on? Page?
Sorry, 312.
312, yes. Thank you. Yep.
I'll let you quickly glance down it, but you'll see that he states he's going to take away the information Mr. Al-Sadeq has provided, who will then decide what to do about Mr. Al-Sadeq. If you
Just,
start
sorry, just give me one moment just to...
HHSS, as you may gather, is the ruler, shakes hands.
Yes. How much of the next page do you want to see?
So,
all the way down?
Well, half of 302, all of 313.
Yeah.
Yes, and halfway down 314, if you start from "you will sleep tonight and think about this carefully."
Yes. Well, that seems to be almost identical to what is said at the top of 313.
Yes, it's a...
Well, anyway. Yes, thank you.
My lords, we say them...
So in terms of further documents, you say that Mr. Gerard saying he needed to go to the ruler and persuade the ruler whether or not to prosecute indicates that there must have been some recorded conversations with the ruler.
Exactly. We then move on to the next category of iniquity, the conditions of detention. Again, you can get much of what you need from Mr. Chatterley's witness statement, 6th witness statement. In terms of the specific evidence relied upon, let's go to the, I'd highlight the Dr. Mitchell document. In fact, I didn't take you to that yesterday, and I should have done. And I'm going to come back on the questions that my Lord Justice Mell raised about the background to all of this. So again, if it's in supplementary bundle 2, tab 31, page 402. Just to say, this is a note of a partner at Dechert, Mr. Goiter. That's the reference to TG. This is his note.
Sorry, who's TG a reference to, Mike?
Mr. Goiter, another partner at Dechert.
And that is a deletion, is it, after that little black square? It's a redaction after Article 3.
I don't know.
Appears to be.
We'll check that point. Since we're here, I rely on this as, again, showing that there must have been something that's gone wrong with the application of the test. Can I? So it's something that I would take you to under the point 3 about strong prima facie case, that there must be other documents. Can I just address again the background to this?
I'm so sorry. Before you do, but yeah. Yes, just remind me. I ought to have Hunt. DH is Hunt.
Hughes.
Sorry, yes, Hughes. And Jamie is
Mr. Buchanan.
Yeah.
Representative of the client.
Yeah.
Now, again, let me just explain the background to Dr. Mitchell's inspection. I referred you to Mr. Allen's 9th witness statement, paragraph 73, supplementary bundle, page 136, about his instruction. Dr. Mitchell was engaged by Dechert to produce a report to assist the extradition of Mr. Izad Panar from Italy to Ras Al Khaimah. And it was envisaged that Mr. Izad Panar, if that extradition request was granted, would then be detained with Mr. Al Sadeq and Mr. Kuzma at Al Barirat. Now, Al Barirat was not a prison within RAC's criminal justice system, but a military camp for the ruler's private militia. That is pleaded by Mr. Al Sadeq at paragraphs 105 to 108 of his particulars of claim, where he pleads he was detained there under a false name. That's in the supplementary bundle, tab 11, page 219. I should say that allegation is not admitted by the defendants. That's paragraph 91 of their defence, page 258 of the supplementary bundle. But there are documents from the defendant's disclosure which record Al Barirat being described as a military prison or a military barracks. And you'll see the reference for that in Mr. Chatterley's 6th witness statement, paragraphs 81.5 to 81.8, supplementary bundle, pages 53 to 54. So, my lords, there were only 2 detainees at Al Barirat, Mr. Al Sadeq and Mr. Kuzma, although they weren't permitted to interact with each other. RAC then sought to extradite Mr. Izad Panar, who is another alleged co-conspirator of Dr. Assad, sought to extradite him from Italy so that he too could be detained at Al Barirat. And it was for that purpose that Dr. Mitchell was instructed. And it's Mr. Al Sadeq's case that it was on that, is that before that visit, the conditions at Al Barirat were artificially improved so as to give the impression that the conditions were acceptable. Notwithstanding that, Dr. Mitchell still concluded they were in breach of Article 3. So in other words, Mr. Al Sadeq's case is that the instruction of Dr. Mitchell was an attempt at whitewashing. And that is Mr. Al Sadeq's pleaded case, paragraphs 111 to 112 of his particulars of claim, supplementary bundle, tab 11, page 220. And that allegation, I should say, is again not admitted by the defendants. Defence, paragraph 94.4, supplementary bundle, tab 12, page 259. Then, as you've seen, Dr. Mitchell made his conclusions about the conditions, and that's recorded in the Dechert note that you've just seen. So just to pause there, the relevant iniquitous purpose, we say, was to extradite Dr. Izzad Panar to Iraq so that he too could be detained in conditions in serious breach of his human rights, like Mr. Al-Sadeq and Mr. Kuzma, all as part of the investigation. And it was in furtherance of that purpose that RAC sought via Dechert to instruct this expert, Dr. Mitchell, to produce a favourable report to facilitate that extradition. So we say the communications with Dr. Mitchell concerning that inspection were part of the iniquity. Now, just to address a point that one of your lordships raised about, well, couldn't there be an innocent explanation for this instruction? Perhaps Dr. Mitchell was asked to report in a bona fide way and then did report. We say that isn't what the evidence shows, and we say the balance of the evidence does demonstrate that the attempted whitewashing exercise did happen, that Mr. Al-Sadeq alleges.
But in any event, perhaps I misunderstood what you mean by in a bona fide way. Obviously, there's no attack on the bona fides of Dr. Mitchell anyway. No, I thought it through. I see how you put it. Thank you.
But you're addressing two separate strands of your argument here. One is the question as to whether the conditions in which he was held were unlawful,
yes,
inhumane and degrading treatment.
yes,
The other is whether there are further documents which fall within your
yes,
definition of the relationship
yes,
test.
yes,
And so far as the latter is concerned, you say that is so because, from the point of view of the ruler at least, and with Dechert's involvement, this was a whitewashing exercise. And the only evidence, is this right, that suggests that it was a whitewashing exercise as opposed to simply a straightforward instruction of Dr. Mitchell is Mr. Al-Sadeq's evidence in the pleading that the conditions were sought to be improved prior to his visit. Is there anything else in the
yes,
evidence
there is. I was just about to refer you to that. Let me take you to that. It's in Mr. Chatterley's.
Sorry, can I,
Yes,
at the risk of derailing you, which I'm sure it won't. Might it not, even if it wasn't a whitewashing exercise, if the intention was to detain him unlawfully to put pressure on him, whatever the nature of the prison conditions, i.e. whether or not they were in breach of Article 3, wouldn't that fall within the furtherance of the purpose?
Might I repeat that again?
Even if there was no intention to conceal that he was in breach of Article, even if there was no purpose to paint a false picture of his conditions of detention, would it not still be within the iniquitous purpose to obtain a report so as to get Mr. Can't pronounce his name, Mr. Panar, into unlawful detention in military barracks in RAK?
Well, yes, I suppose that comes back to the breadth of the test and whether something that simply reveals something about the iniquity would be caught.
Yeah, I don't want you to make a point you're not making. I was just trying to think it through for myself. Come back to the specific point about the whitewashing.
Yes, I will. So there is, it isn't simply the pleadings. If you could look at Mr. Chatterley's sixth witness statement, supplementary bundle, tab 2, page 53. So starting at 81.6, which is on page 53, prior to Dr. Mitchell's visit, he was told that the maximum period of solitary confinement was 7 days. Mr. Sadeq was in solitary confinement for 560 days. If you look at subparagraph B in the note of the meeting there, that records Mr. Buchanan, it's a note of Dechert, which records Mr. Buchanan telling Dr. Mitchell that Al-Barirat is clean and very lovely. Then if you look over the page to paragraph 82, Dr. Mitchell's note itself states that Mr. Hughes, the Dr. Mitchell note, the one produced by Mr. Goiter, itself states that Mr. Hughes may have a similar note of Dr. Mitchell's findings, but that Mr. Buchanan may want it removed from the file. And then at paragraph 85, you see what Mr. Chatterley says there, that Mr. Hughes's notebook does indeed have pages missing on or around the date of Dr. Mitchell's visit to Al-Barirat. Sorry, Mr. Paul has just also reminded me, if you just go back to 81.8, the bottom of page 53, that's a note of a meeting summarising the deficiencies identified to Dr. Mitchell. And if you see from the quotation there, he refers there to misleading info.
Yes.
So, my lord, that's I was going through the evidence note in equity 2, and my Lord Justice Popplewell is right. I was really addressing there as well the point about why we say that there's a strong prima facie case that documents exist, but that I did that because we had it open at that point. As to the other documentary evidence we would rely on in addition to the Dr. Mitchell documents, we've got them all listed there, but we would also ask you to highlight in particular the reference to the note about Mr. Sadeq being sometimes in shackles. The following one at F, a note of a meeting on the 7th of October, recording that Mr. Sadeq has been in solitary confinement for 13 months and in a very small prison cell measuring by 3 metres and 1.5 metres. And then we'd also highlight H, the internal Dechert email, which we say has some rather odd redactions. Then you've got our examples of communications we think must be caught, and I've obviously dealt with the Mitchell note, and I just refer you to one more. And that's to Lloyd Firth, an internal Dechert email of an associate, Lloyd Firth. You'll find that again in the second supplementary bundle.
Is this the one referred to at 19B?
Yes, it is. I could just leave you to read that. It's not long, as you see most of it's redacted. Go over the page as well.
Yes.
So we say that there must be communications with, we know that Mr. Gerard was asked to discuss these with the reference to Jamie as to Mr. Buchanan. must have been communications about whether the conditions led to Mr. Sadeq providing information, whether those conditions should be continued, and so on. And also then the third category of iniquity is the denial of access to legal representation.
Why do you say that whatever is redacted must relate to the conditions that he's in? This is the 10th of October, the day after.
I'm not saying specifically that these redactions, but there must be some communications that took place because...
Yes, I quite understand must be communications. It's suggested that certain matters should be raised with Mr. Buchanan, but why do you say that the implication is that those were discussions about the conditions in which he was being held?
Well, they will have been, no doubt, have included discussions about Mr. Sadeq's cooperation and what information he may or not have been provided, and we say those were all part of the iniquity.
That's a different point.
Issue number 5 to be raised has to do with Mr. Sadeq being blindfolded, I suppose.
Well, he was told the blindfold was removed before the interview commenced. Such steps conflict with what has been communicated to Cass to date, which is that he will be rewarded for full and frank cooperation. When it was the third category of iniquity, I'm not going to just deal very briefly. The ones I'd particularly highlight in the specific documents are at 23, C and D, referring to Mr. Sadeq not being legally represented, no access to legal advice, and also to Mr. Sadeq's witness statement.
Thank you.
Let me deal very briefly. I'm about to finish on iniquity, but just to deal with what the judge's analysis is. And we say against all of this material, we submit the judge was plainly wrong in his extremely brief treatment of the evidence, in concluding that he wouldn't have found that we'd established the iniquities to the standard of a strong or a very strong prima facie case. And you'll have seen he addresses it in the judgment in a single paragraph, paragraph 115 of his judgment. He didn't do any analysis of the evidence. All he did was refer to the submissions of the respondents, which he'd summarised in 3 paragraphs, and he indicated that he broadly agreed with them. So let me just, if you want the passages in the judgment, page 165 of the bundle is his conclusion. But he, as I said, he said he would have, he broadly agreed with the submissions of my learned friend, and that those submissions are at 101 to 103. Let me deal very briefly with those. 101, the judge just recorded my learned friend's submission that the fact that a copy of the extradition request from the Iraq authorities to Dubai is not in the possession and control of the defendants doesn't mean that no such extradition request exists. But obviously we didn't simply rely on the absence of such a document in the respondent's disclosure as making good that submission that no request had been made. Although we do say that the judge was wrong to regard its absence as not of great significance. But there are obviously all the other matters which you have in the note that we rely on in support of that. So it wasn't simply that fact. 102 of the judgment, the judge simply records the respondent's submission that, save for in relation to al-Barirat, the evidence put forward by Mr. Sadeq didn't demonstrate a very strong prima facie case that the allegations he makes are true. Well, my lords, with respect, that's entirely circular. That's not a reason why the evidential threshold hadn't been met. It's just an assertion. And then 103 of the judgment, he deals with the third iniquity, and he records the submission that on the evidence from the April 2015, Mr. Sadeq had been actively represented by the lawyer, Mr. Al-Shamsi, and that prior to that time, it was the understanding of Mr. Gerard and Ms. Black that Mr. Sadeq was unrepresented on a voluntary basis. I just make 3 points on this. First, it appears to entail an acceptance that during the pre-April 2015 period, Mr. Sadeq did not have any access to legal representation, but the respondent's case being that was on a voluntary basis. Second point, the judge didn't explain why, in the light of this dispute of fact, that the understanding of Mr. Gerard and Mr. Black about this, which we say is inherently improbable, he didn't say why their evidence was to be preferred. And he also thirdly, didn't explain how Mr. Gerard's and Miss Black's understanding was to be given greater weight than the documentary evidence relied on by Mr. Sadeq, which we say demonstrates that at any rate during the pre-April 2015 period, he was actively seeking legal representation, but appears to have been blocked. The last point on inequity is about formulating the order. If my lords were found that we had satisfied the necessary evidential burdens, my learned friends appear to accept that the order has to be fashioned in a way to capture documents to be disclosed. That's their skeleton, paragraph 13, page 77, core bundle, and paragraph 54 of their skeleton, page 89 of the bundle. And we've given in our appeal skeleton the examples of various different orders that have been made in other cases where the exception was made out in paragraph 46, core bundle, page 50. But we say that our formulation of generated by or reporting on is apposite in this case, and unlike the defendant's formulation, would capture documents which are part of the iniquity. It doesn't, of course, need to be appropriate for other cases. It doesn't need to reflect any legal test. It simply needs to be appropriate for this case. And I'd only add that it is open for the court to refine that or to provide for certain carve-outs, as my Lord Lord Justice Popplewell did in Ablyazov, to modify the order. And there were carve-outs, in fact, as well in Darby & Co. and Weldon made by the court, and in Barclays Bank and Eustace. My lords, the transcriber asked if she could have a 5-minute break, and I'm going to move on to litigation privilege. So is that convenient?
I think we'd better do that. Yes, thank you very much. We'll come back out in 5 minutes, just afternoon.
All right. I might. Oh, yes. By the way, do you want, I've got lots of water. Do you want that? The note, which was that the short before?
Yeah. Just check it's not mine.
It's difficult for you otherwise. I'm sorry, I realise I'm speaking a bit fast. All right.
Sorry, 5 minutes is never 5 minutes.
My Lords, litigation privilege, as you know, we have a general challenge, and then there's a point about whether third parties can claim litigation privilege. Dealing first with the general challenge, we say the defendants have failed properly to substantiate the claims to litigation privilege. The evidence in support is wholly insufficient. You'll recall the observation I made in my opening remarks that we have no evidence at all that is said to be on the instruction of the clients whose privilege we are concerned with. And we are not aware, on this side of the court, of any case in which a litigation privilege claim was not supported by evidence from one or both of the privilege holder or the privilege holder's lawyers in respect to the relevant litigation. The defendants elected to deploy Mr. Allen's 9th witness statement, elected not to deploy really other than a handful of any contemporaneous materials to support the claims to litigation privilege, contrary to the invocation to do so in the West London case. So the evidence is, we say, mainly based on assertion. Now, the crux of the respondents' position on this part of the appeal is that they say there is no basis for disbelieving Mr. Allen as to what he has said in relation to making good the claim to litigation privilege. That's paragraph 65 of their skeleton, page 91 of the core bundle. That is, however, missing the point. The issue is not about whether Mr. Allen is to be disbelieved, but whether he has provided sufficient evidence. I need to take your Lordship very briefly to the West London case, which, as you know, is the case cited in this area. It's behind It's in your second volume of authorities, behind tab 27, page 609. My lords will remember this as the case that arose out of the Buncefield explosion. The privilege arose in this way. TAV, a third party, was seeking disclosure of documents over which the defendants had claimed litigation privilege. And you will see reference to two groups of defendants, the total defendants and HOSL, the Hertfordshire Oil Storage Limited. Now, Mr. Justice Beatson concluded that the claimed privilege by the defendants wasn't made out. And if you look at the head note over the page on page 610 under point 2, you'll see he refers to the fact that the affidavits were unsatisfactory and didn't disclose all the matters they ought to disclose. Now, the evidence that was given in support of the litigation privilege claims was contained in the following affidavits. On the part of the total defendants, there was an affidavit from Mr. Malcolm Jones, who is the MD of Total UK, and on behalf of HOSL, there was an affidavit from Mr. Richard Jones, the director of HOSL, and also a partner at Eversheds, Mr. Young, who attended relevant board meetings. And you get that, my lords, from paragraphs 4 and 6 of the judgment. So there was affidavit evidence from representatives of the two defendants and the putative privilege holders. Then you may want to flick through, I'm not going to take you, but there's this paragraph 7 to 31 gives a flavour of the nature of the relatively extensive evidence that they gave. And then, just to draw your attention to paragraph 44, there's a remark there by the court. There was no affidavit in support of the privilege claim from the relevant...
Sorry, which page are we on?
We're on page 622. Although Davis Arnold Cooper's letter there, at the beginning of that paragraph, 44, the court is noting that there's no affidavit in support of the privilege claim from the relevant lawyers conducting the defence. I think that's the defence of the total defendants. And then there's a lengthy quotation from the affidavit of Mr. Malcolm Jones, which, although you see that over the page, we've sidelined it, although that contains far more information and evidence to support the claim to litigation privilege than the respondents have served in this case, it was ultimately found to be insufficient. Can I take you to paragraph 53 of the judgment at page 629 about what Mr. Justice Beatson says there about affidavits claiming privilege in the first six or seven lines there. So, my lord, we say in a typical case, one would expect to see evidence from either the privilege holder or the privilege holder's lawyers in respect of the relevant litigation. We have neither in this case.
Can I just understand what you're suggesting should be there? If Decherts had themselves claimed the privilege, that's what you'd normally expect on behalf of a client, that the solicitor will claim the privilege. You suggest that if there had been information from Decherts that the privilege was made out, that would be sufficient. But in order for Decherts to be able to say that, they would have had to have conducted the disclosure exercise, as to which I thought you would have screamed blue murder.
Well, I think there needs to be consultation with them about the points at which litigation, once a date, the solicitors conducting the disclosure exercise conclude what they consider to be an appropriate date, then that is the point at which evidence should be sought from those who are conducting it to satisfy the objective test and confirm that that is what indeed the client at the time was anticipating.
So this point is confined to the date when litigation was contemplated.
Yes. There's then the well-known passage in this judgment, which is well known and cited in the judgment of Judge Below at paragraph 86, and it's page 640 of this bundle. Now, you will have seen what we say in our skeleton, where we say the judge went wrong in applying the reasonably certain test or criterion. And we say what is set out here doesn't require that the court needs to be reasonably certain that the evidence is factually wrong. The court may also reach the conclusion that it's reasonably certain that the evidence is incomplete. And indeed, the respondents seem to accept that at paragraph 74 of their skeleton, page 93 of the core bundle. Just to finish on this case, Mr. Justice Beatson applies the principles that he sets out to the facts of the case at paragraph 92, which is page 643 of the bundle. And if you look at the sideline bit at the bottom of the page, he then considers whether the affidavits of Mr. Jones of total, and he considers that they're unsatisfactory and are insufficient to make good the claim to litigation privilege. And he notes that no documents have been exhibited to support what Mr. Total says about the purpose of establishing the total AIT. And in fact, the judge goes on to list various matters in paragraph 99 about various matters which he thinks Mr. Jones should have given some explanation for. And you then get the conclusion, punchline at the end of paragraph 99, over the page on 645. The affidavit is thus at a minimum incomplete on matters which is necessary for the court to know in order to determine the claim privilege. And my lords, in that case, the court decided it wasn't appropriate to require disclosure, but that Mr. Jones should be ordered to go away and swear another affidavit.
Forgive me, it's obvious to you. So the short point is, it would have been sufficient if Mr. Allen said, I have had confirmed to me by Dechert that these were the dates when litigation was contemplated, but in the absence of that, the affidavit is incomplete. Is that
no, I don't think it would. No, well, first of all, that doesn't deal with the fact that one can't simply have it on instruction. One needs to have, as Mr. Justice Beatson says, contemporaneous documents. I don't think it would be sufficient to say I've spoken to Dechert.
Would those documents not be privileged?
No, I don't think they would. And I'll come to tell you why.
Oh, right, sorry.
I don't think they would.
You're going to come and tell us why.
Yes. But just to complete on that point, my lord, there needs to be someone who says on instruction this was what was contemplated by the privilege holder. And there would need to be not only something from Dechert, but that Dechert confirming that it was their understanding that was what it was in the minds of their clients, not just in their minds. My lords, we also rely on a few other authorities. I don't have time to take you to them, but just for your notes, Starbev, although that's the decision of Mr. Justice Hamblin, and his summary of the principles are often cited there at page 755 to 6 of the authorities bundle.
If there was a document which said, for example, a Dechert document which says the client has asked us to prepare for litigation and these are the steps that we're going to take, that would be both privileged and a sufficient basis for Mr. Allen to say that the client contemplated litigation was contemplated, wouldn't it?
Well,
So you wouldn't need, I mean, Mr. Allen, if he had that document, I don't know if he did or not, I don't suppose so, but if he did, that would be quite enough for him to give the necessary evidence.
well, I'm not sure in the absence of, and I'm going to, perhaps you can test this further when we come to look at the specific bits in Mr. Allen's table and why I say there must be some contemporaneous documents and it's not, that aren't privileged, and it's not satisfactory simply to say everything is privileged. And the fact, and I'll also come to the fact that solicitors are instructed is not of itself sufficient to establish. In fact, the case is made clear. You may well instruct solicitors on a matter, an investigation. That doesn't establish that litigation is in reasonable anticipation. My lords, Starbev, as I say, we've referred to in our skeleton. I just refer you to the fact that in that case, Mr. Justice Hamblin again found that the claim for litigation privilege hadn't been made out. There hadn't been established that the claim was in reasonable contemplation. And again, that is a case where there was documents from the privilege holders. So there were two sets of documents in that case. But you'll see, if you look, it's not a long case, there were documents from the privilege holders. Indeed, the court, interestingly, at paragraph 40 in that case, page 762, criticised the fact that Mr. Southwell...
Mrs. Oppenheimer,
yes.
I understand you'll be trying to be economical, but I think it's worst of both worlds.
I will leave.
Take us to it if you like. But if you don't,
I will
you
move
need
on.
to.
I don't
Okay.
need it. And
Okay.
you have what I've said in relation to West London. But I do rely on the fact that we've relied on it in our skeleton, and that there are other cases referred to in our skeleton, such as SFO and ENRC and Qatar and Bank Haviland, where the evidence was far more extensive. So let's turn to what the evidence is. Mr. Allen's ninth witness statement, effectively the table you'll have seen referred to. It's in Supplementary Bundle 1, tab 7, page 155. Now, the respondents also rely on some introductory passage in Mr. Allen's witness statement, which they say also forms part of the evidence, and there is also some commentary, additional commentary on some of these entries in the table further on in the witness statement, which I will come to in a moment. But in essence, we say Mr. Allen's evidence really amounts to not much more than what is in this table in respect of all these different litigations. And we say that it's startling how little evidence is provided, particularly when one compares to those other cases I've referred to, including West London, the West London case. And in my submission, the court simply doesn't have sufficient information to assess whether the claims have a proper basis for litigation privilege, particularly if one applies the objective test of whether litigation was reasonably contemplated at the dates alleged. And it's,
Sorry, again, does this point go any further than the date?
no. And Mr. Allen repeats that it's clear to him, but that doesn't meet the point. And I've made the point about absence from the defendant's clients. And we would expect to see evidence that someone has spoken to the client to be able to substantiate why the dates are the ones that they say. Now, to deal with the point that's been raised by my lords about, well, wouldn't anything else that he needed to provide, the type that I'm asking for, wouldn't that involve providing privileged communications? We say no. I'm going to give you some examples of why we think there must be some information that could be provided that wouldn't require waiving privilege. And in any event, the evidential burden still stands, and the defendants cannot simply say, well, we've done enough because everything else is privilege. In the case of Kyler that we cited in our skeleton, paragraph 60, page 58 of the core bundle, is such an example. That precise point was taken by the privilege holder, saying, well, it's all very difficult. And Charles Hollander, sitting as a deputy, said, well, I see that, but you haven't made out your evidential burden. It's worth noting for cases such as ENRC, the decision was taken to waive privilege over a handful of documents in order to make good the claim. Can I make some general... I'm going to give you a few examples of why we say some of these entries on the table are inadequate. I'm not going to go through all of them. But there are a few general points which are applied to a number of entries. The first is reliance for many of the categories that lawyers were engaged in another jurisdiction. As I've already said in response to my Lord or Justice Mells, we say that's not sufficient to establish that proceedings were in reasonable contemplation. Lawyers may have been instructed to ascertain whether there's any sort of claim that can be brought. As I said, there are examples in the case law of courts saying, well, the fact you've instructed solicitors is not enough. The best reference for that is Philip Morris. I'm just going to give you a single paragraph. Authorities Bundle, tab 22, in the Court of Appeal, page 450, Lord Justice Brooke saying, I consider it would be impossible to conclude that litigation against the company was reasonably in prospect when that company engaged the solicitor's services. So you just need to look at that one paragraph. Qatar and Bank Haviland was another case where the fact that lawyers were instructed by the bank wasn't sufficient to make out the claim for litigation privilege. So that's one thing you see in relation to a number of these entries. We again have Mr. Allen personally having considered the issue, but I say that doesn't take him anywhere. And the third is an absence of any information to explain the factual basis for the suspected alleged fraudulent conduct. And let me give you an example of what I mean. If we turn to row 1, which is these Georgian civil proceedings against Mr. Mikadze and others, that's page 155 of the bundle. Mr. Allen comments in the right-hand column. By mid-July 2013, Dechert had identified both that Mr. Mikadze had close connections with Dr. Mossad and also significant indicia of fraudulent conduct. Now, my submission, it would be perfectly possible to say what the elements of the indicia of the fraudulent conduct they say existed without requiring a waiver of privilege. Privilege protects, obviously, the communications between lawyer and client and communications made for the dominant purpose of litigation, but simply providing information as to what in the indicia of fraudulent conduct may be, that wouldn't require a waiver of privilege. Row 3 is criminal proceedings involving the claimant, Mr. Kuzma and Shahab Izad Panar and ENRAK. I'm going to come back to the third party point. Now, again, we say that the fact that there's a specific piece of information here about Izad Panar's ownership doesn't go far enough to explain why proceedings were in contemplation. And the fact that Dechert provided advice doesn't of itself get you over the hurdle of litigation being a mere possibility. I just note here there's another unsatisfactory aspect of this claim. It's dealt with separately in our skeleton at paragraph 89, but there's been a change of the claim of privilege here. Initially, privilege was claimed over documents for the whole of from the beginning of September, and then it changed to from the 9th, from the date of Mr. Al-Sadeq's arrest. And we're told that, well, yes, that's right, but litigation privilege is still claimed in respect of other litigations, but we're not given any explanation for how privilege could arise in respect of such communications that are for the dominant purpose of other litigations.
This, I think, is the third and last of the iterations of the look table that I've seen.
Yes.
At page 155, and the identification of the 9th of September as the date, is that in the evidence before? Did that come at the hearing or sometime before the hearing?
I think it's on the basis that, taken from the, said that it's not claimed for any period prior to his arrest. I'll need to find the exact, prior to interview with Dechert, I'm sorry.
Don't worry now, perhaps you could just find that.
Yes, I will. Very briefly, paragraphs 4 and 5 talk about Dechert commencing work or seeking law advice with foreign lawyers. So, for example, in paragraph 5, entry 5, Dechert commenced work with local UAE lawyers, Sadeq and partners regarding these potential claims. Again, that's not enough. Just because they engaged foreign lawyers or commenced work doesn't establish that litigation was in reasonable contemplation. It might well be a bogus claim, and Dechert may have concluded that there was no prospect of any litigation ensuing. So it may be a factor, but it's certainly not enough to get over the hurdle. And then can I just deal finally with row 10, the civil and criminal proceedings against Dr. Masad and related parties.
You can contemplate litigation for these purposes, can't you? Even if subsequently you're advised that actually prosecution of the claim would be hopeless, so you shouldn't undertake it. And if I instruct my solicitors to put together a claim to sue X, and I contemplate litigation against X, then the communications are still in contemplation of that litigation, even if I'm advised that there's a hopeless case, and I never sue X.
Maybe, my lord, but that has to be looked at against the test of getting over litigation being a mere possibility. And if that is the case, then one would expect to see other reasons why, factual reasons why it is that litigation was contemplated at that juncture. If I can make that point good in relation to row 10, the defendants say that civil and criminal proceedings against Dr. Masad and related parties were contemplated from the outset of Dechert's instruction, because allegations of wrongdoing and recovery of allegedly misappropriate assets was the primary reason why Dechert were engaged. In my submission, that reasoning is circular. It simply proceeds from the premise that because Dechert were instructed, litigation must have been in reasonable contemplation from that date. As I've said, we say the fact of engagement of a law firm isn't determinative. There may be an initial investigatory phase where one hasn't yet moved from the mere possibility of litigation. And we say this language overall is vague and doesn't really provide anything in terms of information which enables us to analyse whether that assertion has a proper basis. And the important point is this: what is the material which indicated that a fraud had been perpetrated? I've already said that doesn't require the defendants to divulge privileged communications. There's nothing to preclude them from listing out the facts they rely upon as establishing the indicia of the alleged fraud of Dr. Masad. My lords, there's another important point here. We say the vagueness of this justification is particularly significant in this case, given that one of Mr. Al-Sadeq's core allegations is that the so-called suspicion of widespread fraud was a pretext. So it should be even more incumbent in a case like this that the defendants should at least be saying, well, here are the elements of fraud that we consider to have been committed, and this was why litigation was commenced.
I'm afraid I don't follow that. If, as is your case, this was all a vendetta to procure evidence for trumped-up charges which were going to be prosecuted, is litigation not just as much contemplated by that activity as it is if the fraud is well established?
Well, it may be if there's an intention to commence litigation which has no prospect but is going to be initiated.
That's your case. I thought that's your case. Is that what this was all about? That it was intended with at least Dr. Masad as the target to pursue him on false charges, one presumes, by way of litigation.
No, I can see, my lord, that there's a tension in my submissions there, but that This is a separate, discrete issue as to whether sufficient evidence has been provided to make good these claims. And that will be potentially relevant if I don't succeed on my crime fraud challenge. The fact is that the evidential requirements set out in the West London case still need to be satisfied, and we say they haven't been in this case. And that what we have here in respect of 11 types of litigation, a few comments with a few embellishments in the paragraphs that follow, is simply not of the type of evidence that is contemplated for claims of this sort.
Is that's your case on the general defects?
Yes, right. Shall I move to the third party point? My lords, the issue here is whether the judge was correct to find that the defendants can claim litigation privilege on behalf of their clients, RAC Development and RAC IDO, in respect of communications produced for the dominant purpose of criminal proceedings against Mr. Sadeq and others, in circumstances where their clients were not parties to those proceedings, but were the putative victim or complainant. And as you know, the judge found in favour of Mr. Sadeq on that point. We say that constitutes a significant, inappropriate widening of the scope of litigation privilege. My learned friends seek to underplay that widening, of course, but as I'll come to explain, it does represent a significant extension of privilege and leaves the scope of litigation privilege in a state of very considerable uncertainty. Just to explain the context in which this arises, it applies, if you've still got Mr. Allen's table open, it applies to rows 2, 3, 8, 9 and 10.
2, 3, 8, 9 and 10.
2, 3, 8, 9 and 10. There's reference to another set of criminal proceedings at 11, but those are against Dechert and Mr. Gerard in Switzerland, so that's not a third party point. So 2, 3, 8, 9 and 10. And if we said
so all of those are
criminal,
well, except for the extradition proceedings to date.
They're not ones to which Dechert's clients were a party. Now, this is an important part of the defendant's claims privilege because it goes to over approximately 7,000 documents which have been withheld entirely on the basis of privilege. Can I deal first with, I want to explain why the judge's conclusion is contrary to basic principles and the rationale of litigation privilege. I then want to look at two of the authorities in particular, and then I want to address why the sufficient interest test that the judge formulated is wrong and problematic. Dealing first with litigation privilege and its rationale, I think your lordships will be familiar with this, so I'm going to deal with this pretty quickly and give you the references, if I may. There are 3 points to make under this heading of litigation privilege and rationale, and they're these. First of all, litigation privilege is concerned with the conduct of litigation. Secondly, there is a well-established rationale, an understood rationale for litigation privilege, and it doesn't apply to third parties. And the third is that it is clear from the cases that determining the precise limits of litigation privilege involves striking the balance between two imperatives. And we say that the striking the balance here clearly requires not extending the privilege in the way my learned friends say it should be. So first of all, litigation privilege is with concerned with the conduct of litigation. Non-parties are by definition not conducting litigation. I'm going to come back to the insurer-insured situation because there may be particular circumstances when an insurer is effectively conducting it. But as a general proposition, non-parties do not conduct litigation. If I can just take you very briefly to 3 Rivers 6 in the second authority bundle at page 491, tab 25. just while my lords are turning it up, obviously this is the leading House of Lords case on the scope of legal advice privilege. But as it explains the whole origin of legal professional privilege and explains that the two limbs are two heads of a single privilege, there are, we say, some authoritative statements about litigation privilege too. I just want to take you to Lord Carswell's speech, 556, page 556 of the bundle, paragraph 102. You could just read that.
Yep.
Could you just, while you have the decision open, turn back as well in Lord Carswell's speech to paragraph 86? And the reason I ask you to do that because it supports my third point about how one determines the precise limits, and you'll see him there discussing striking the balance between the two imperatives. That's paragraph 86, page 548.
Just remind me of the authoritative structure of this. There were speeches from all the members of the court, I think.
Yeah.
But Lord Stott and Lord Carswell were the ones who everybody agreed with. Is that right?
Yes. And it's quite difficult working out who agreed with whose speeches, but yes, those are the two main speeches from Lord Stott and Lord Carswell.
Yes?
Now, you can put
Sorry
that...
to stop you, but that is talking about litigation, about legal advice privileges. It's introduced by saying that one of the two competing considerations is avoiding unfairness for individuals by revealing confidential communications between their lawyers and themselves.
Yes.
And that's firmly the legal advice privilege.
It is a legal advice privilege, but as I say, they're two limbs of the same privilege, and determining the bounds of privilege generally requires balancing such considerations. I'll make good the point, my lord, also in, I think it's worth, sorry, to just within that case, to note that actually Lord Carswell also refers to the speech of Lord Edmund Davis in War, and that's obviously a case all about litigation privilege, not at all about legal advice privilege. Wasn't going to take you to war, but I can. But that is, I don't think there's any dispute that that is only a case about litigation privilege.
Yeah.
Next, if you wouldn't mind putting that away and taking out the next volume of authorities. Again, just to make this point that litigation privilege is about the conduct of litigation. Tab 36, decision of the Court of Appeal in WH Holding, West Ham and E20, page 894. My lords, the issue here before the Court of Appeal was whether emails that were passing between board members of the defendant, which were made for the dominant purpose of discussing a commercial proposal for settlement of the dispute, was subject to litigation privilege. And the Court of Appeal held that they were not, because they were not documents which sought advice or information for the purpose of conducting litigation. In essence, they said it wasn't sufficient that the emails could be said to be for the dominant purpose of obtaining advice or information in connection with existing contemplation. There was also that general principle was subject to the qualification that the communications must have been made for the sole or dominant purpose of conducting litigation. And you can see that if you read page 898, beginning paragraph 11, and then over to page down to paragraph 15, where in the end they reject Mr. Plewman's argument and say that no, there needs to be this qualification that it has to be communications that are made for the sole or dominant purpose of conducting litigation.
So where exactly do they say that?
In 15. The only reason I didn't take you only to 15 is it's quite difficult to follow if you haven't read paragraphs 11 to 14, but the point I'm making is in 15. It's the final sentence.
Yes, I see.
If my lords turn over the page, you'll see the reference in paragraph 17 to the decision in Excalibur, the decision of my Lord Justice Popplewell, again confirming that litigation privilege doesn't cover all documents brought into existence for the purposes of actual or contemplated litigation. And I know that that example has been cited in other cases that my lord gave in that case of a litigant who goes out to buy a suit for the purposes of a trial, that purchase of that suit, documents evidencing that wouldn't be subject to litigation privilege, albeit they're for the purposes of it. They're not for the conduct of that litigation. So, my lord, that is the point. My first broad point about litigation privilege is about conducting litigation. Third parties don't conduct litigation. Second is the rationale for litigation privilege. I hope that this is uncontroversial, that the rationale for litigation privilege is providing a private sphere in which a party can prepare for litigation, and there's no rationale for protection, we say, where an individual is not a party to that litigation. There was obviously a lot of discussion in the case I argued before my Lord Justice Mayles in the Laureley case. And although in that case the Court of Appeal agreed that the zone of privacy is not a test, that is still nevertheless a way of encapsulating what the rationale for litigation privilege is, which is to create a space in which a party can prepare for litigation.
I'm sorry, what's that case?
The Laureley and Credit Suisse case.
Is that in our bundle?
It is in your bundle, tab 53.
How do your submissions on this aspect of the case relate to what you were saying earlier about who is the client? For the purpose of your arguments under the heading of iniquity, you cast the net of who is the client quite widely, so it includes the ruler. For the purpose of your argument now, third party, are you focusing on specific RAK entities as the client, or if not, who is the client?
Well, the clients on the clients, as per the evidence in the engagement letters, are primarily RAK IDO and RAK LLC. My lord is right that we include the ruler in terms of who on the iniquity application side. I don't think anyone has suggested that, for example, RAKIA, the investment authority, which is a party to some of these proceedings, is a client.
Well, I think Mr. Reedy does say that. As I understand it, from his skeleton at least, he says you don't draw fine distinctions between various emanations of RAK, that the letter of engagement, although it initially came from RAK IDO, was obviously on behalf of all emanations of the government. I don't know whether RAK IDO is a separate legal entity. But I certainly understand him to be saying, for the purposes of this point, that all emanations, including RAKIA, are to be regarded as clients. I'm sure tell me if I'm wrong.
Yes, it is. My lord is right. Can I deal? I will come back to this point and probably after the short adjournment. But
You're on the slightly separate point, because it doesn't matter how widely you cast the client, even if they were victims of criminal proceedings, that doesn't make them parties to it. So there's no part of the emanation of the state which constitutes a party to the relevant criminal proceedings.
Exactly.
I understood correctly.
exactly, and the only basis on which you might have someone who could claim privilege when they were not strictly the party to the proceedings is when they are effectively the party all but in name, and that's the insurer-insured situation. And we say that we accept that there is a basis for that. There's some dicta in one case in the Guinness Peat I'll come to, but that we are nothing like close to the in all but name situation that one is in the insurer-insured context.
So the ruler is not a party to criminal proceedings in RAK in the way that the Crown is here.
Correct.
What's it?
We don't think so, but we may have.
Well, it's really quite important, isn't it? Because we have here a number of entities, some where there is, I think, evidence that they are described as legally separate, but they're all emanations of the state, and such evidence as there is about the RAK constitution suggests that we're not talking about a constitutional monarchy, we're talking about an actual monarchy where the ruler calls the shots across the whole range of activities. What is the evidence about those sorts of constitutional arrangements?
I'm not sure there is any before this court.
But isn't it quite important to this point, if we're going to decide who the client is, I don't know who it assists. You go simply look at the engagement letter.
Yes.
But a lot of the surrounding evidence, some of it relied on by you for other purposes, suggests that that's an unrealistically limited view of who the real client is.
Yes, I see that, Lord. Well, can I say one point which is clear on my learned friend's case, is that they say that the RAC public prosecutor is not their client and is independent of their clients. And they make much of that to say that they weren't stepping into the shoes of or doing anything like that. So the RAC public prosecutor was the emanation that was conducting those proceedings. So it is part of their case that whoever the RAC public prosecutor is said to be representing in terms of the RAC state, that is independent of who their clients were.
Yes. Well, I think it's something on which, speaking for myself, I would like assistance as to how far the evidence goes. May well be it's more in Mr. Eadie's interest to take us to that than yours, but between you, it would be important to see what the evidence is.
Do you accept the proposition that identifying the client involves not only looking at the engagement letters, but seeing who was in practice treated as the client?
Yes, I think that must be right.
I'm sorry for having diverted you, but as you see, it may be an important point.
I see that, and let me give some more thought to it over the adjournment. Can I just finish on rationale? I hope, as I said, these principles will be uncontroversial. You see the rationale for litigation privilege set out in the War and British Railways Board, tab 7, page 136. If I can just give you the references for that. Lord Wilberforce, page 146, 7, at letters 531H, and Lord Simon, page 150 of the bundle, at 535C. Again, Lord Simon at 537B, which is, and Lord Edmund Davis at page 157 of the bundle, page 542, C to G. well, to the extent that there are cases which support the proposition that litigation privilege can apply to a non-party, those can be rationalised on the basis that the entity which is able to claim privilege, as I said, is equivalent to a party for the purposes of litigation privilege. For example, an insurer or possibly a funder with conduct of the claim. But we say those are consonants supportive of the proposition that litigation privilege is concerned to protect communications which are about the conduct of litigation and is also consistent with the rationale for litigation privilege. This proposition put forward by the judge that should be litigation privilege should be available to putative victims of a crime or anyone who has a sufficient interest in the litigation is something very different and of greater scope. And I'm going to come back to sufficient interest. Just to finish on this aspect of the law, I talked about my proposition 3, determining the precise limits of litigation privilege involves striking the balance between the two imperatives. You saw what Lord Carswell said in Three Rivers 6. His statement, incidentally, was referred to in my Lord Justice Mell's judgment in Laureley, which is at tab 53 of the Authorities Bundle, page, the 5th volume, page 1600. And we've noted in our skeleton that in the prudential case in the Supreme Court, Lord Neuberger, in looking at how one would strike this sort of balance between imperatives, he took the view, when considering whether accountants should be able to claim legal advice privilege, he found it was not appropriate to expand the scope. Well, can I just finish before the break? I think I just need to deal with two authorities which we say are consistent with our position. Reliance is placed by my own friends. We say it's consistent with what I've said. And the first one is Guinness Peat. You'll find that in the first volume of the Authorities Bundle. We're behind tab 11. Page 181. This was a case where the claimant, a building developer, brought a claim against the defendants, their architects, for breach of contract. The defendant architects inadvertently included in their disclosure a notification letter to their indemnity insurers in which the defendants had expressed the view that there had been an error for which they were responsible. And at first instance, the letter was held to be privileged, and the Court of Appeal then dismissed the appeal on the basis that applying the dominant purpose test, the letter was held to be, they dismissed it on the basis that the letter was privileged because, in summary, the insurer's purpose in procuring the letter of notification was to enable it to obtain advice and potential claims. And the issue in the case was whether, applying the dominant purpose test, the letter was privileged in the hands of the architect being the party to the litigation. So we say this is not a case in which the issue of whether litigation privilege could be claimed by a third party it rose for decision because the insurer wasn't the party claiming the privilege, the insured was. Now, the court considered two issues. The first was whether the letter was privileged, and the second was whether, if it was privileged, privilege had been lost. But most of the argument was on the first issue. And the court's main focus for the whole judgment, and indeed this is how the case has been understood in subsequent cases, its main focus is all about whose purpose was material for determining whether the dominant purpose had been met. And if you go to page 189 of the decision, of the bundle, 1035C, you'll see that the parties' submissions are summarised, whether was it the insurer's purpose that was material, in which case the dominant purpose was for litigation, or was it only the architect's purpose that was material, in which case the dominant purpose was simply to comply with claims notifications conditions precedent in the policy. And turning over the page to the sideline passages, Lord Justice Slade accepted the architect's submission that the dominant purpose test doesn't necessarily fall to be determined by reference to the actual composer of the document. You see that just between D and E. And then he goes on to consider over the page, if you look at this sideline passage, that the dominant purpose is to be viewed objectively. And he considered that it had been fulfilled. So that's why we say this case is considered to be a case on the application of the dominant purpose test. It's not an authority for the proposition that a non-party can claim privilege. Now, having said that, I must accept that the judgment does address the issue of whether the insured, as well as the insurer, could have a claim to litigation privilege. And Lord Justice Slade answers that in the affirmative. And you see that on page 192 at G to H. Just want to read that. And he cites there Butter's gas.
Yeah.
Now, we say the reason for that is because of what proceeds in the paragraph immediately above, is that he says, in litigation of this sort, insurers will in all but name be the effective defendants to any proceeding. So this is a case where the insurer can be considered to be the effective defendant. We say, pausing there, that the position is different here. As I've said, the defendants contend that the RAC public prosecutor was wholly independent at all times of their clients. That's Mr. Allen's 9th witness statement, paragraph 65, supplementary bundle, page 136. So to the extent that...
Sorry, just give me the
Allen 9, paragraph 65.
Yep.
Supplementary bundle, tab 7, page 136.
Thank you.
So, my lords, we say to the extent that Guinness P can be said to be authority for a proposition that a person whose party in all but name can claim litigation privilege, then that doesn't assist the defendants and indeed would be inconsistent with their own case, that in these proceedings the prosecution of Mr. Sadeq occurred independently of their clients. Can I deal with one final authority before Your Lordship's rise, and that's USA and Philip Morris, which is in the second volume of the authorities. Tab 22. Page.
Just look at paragraph 65 of Allen 9. You say that says that the public prosecutor was not part of their clients. What it seems to say is that they were very clear that Dechert were not seeking to step into the shoes of the public prosecutor. He was responsible for conducting the investigations, giving his own views and taking decisions thereto. I think read that as the concession that you're seeking to rely on.
Well, we'll see if we can come up with some better references, my lord, but it's the thrust of all of the defendant's evidence that Dechert, who was there on behalf of its client, was, as it were, separate to what the public prosecutor was doing. There's no suggestion anywhere that the public prosecutor was somehow part of the client entities instructing Dechert.
Well, I see the time, but I am prepared, if you're going to be quick with Philip Morris, to get this exercise over with. Is it a 5-minute matter?
Well, I hope so, unless there are... Yes, I think I can...
Well,
What you mean is unless I keep interrupting. Yes.
Shall I try, my lords? If it goes over 5 minutes, I'll stop. This
found
ca-
it, yeah.
Thank you, Madam. The case is known best for what it establishes, obviously, about the first limb of the litigation privilege test. Litigation must be more than a mere possibility. But it is cited in Thankey in support of the proposition that litigation privilege doesn't extend to third parties. So that's why I'm...
Yes, but don't, if you want to be brief, just
Yes.
take
Decision
it.
arose out of a request to examine Batco, an English company in the BAT group, to examine their solicitor, Mr. Foyle, in order to make his evidence available in the US. And the reason for that was that there were RICO claims being pursued against other companies in the BAT group in the USA. And the issue on litigation privilege which arose was whether the communications of Batco with its solicitors were privileged. Now, as I said, there'd been litigation involving another company in the group, Brown and Williamson in the US, but the question was whether Batco itself, the English company, contemplated litigation. At 69, the Court of Appeal agreed with the judge that the litigation involving Batco itself was not reasonably in prospect just because there was a prevailing context of tobacco-related litigation. And then the passage I need to take you to is paragraphs 71 to 73.
Shall we read those?
Yes. Oh, sorry, my lords, I just want to check that you're in the right. This is the Court of Appeal's judgment.
Yes.
Yes. 450. My lords, it's not an easy, I know it's not easy to follow because the facts of this case are complicated, but effectively what the Court of Appeal is considering here is that having decided that Batco couldn't have had litigation in prospect in respect of other litigation elsewhere, it then went on to consider the separate question of whether, assuming that non-party disclosure proceedings against Batco were reasonably in prospect, that the fact of the non-party disclosure proceedings could be a basis for litigation privilege to arise. They said it could not, because the relevant advice would simply be about complying with an order, and that wouldn't attract the rationale for litigation privilege. We say, therefore, the decision is supportive of our position that the privilege is not available to a non-party, even if in principle it could establish two limbs of the test. The defendants say this decision doesn't help us because the ratio that one sees here at 71 is that non-party disclosure proceedings couldn't give rise to litigation privilege because they don't qualify as the right sort of adversarial proceedings. That's what they say in their skeleton at 86.2 for page 102 to 3. But my lords, that is not a correct analysis of the decision. The basis for the decision was not that the non-disclosure proceedings were insufficiently adversarial. You can see that at paragraph 73 over the page because Lord Justice Brooke accepts the letter of request process was adversarial, but rather it was because the position of Batco didn't engage the rationale for litigation privilege. My lords, the final point is this. If the defendants were right that a non-party could claim litigation privilege, Batco could simply have said, well, I claim litigation privilege because the communications that I have prepared are for the dominant purpose of the litigation involving my sister company, Brown and Williamson. That wasn't available to them. They couldn't claim it. My lords, that's it.
Thank you. Well, we'll say we'll sit again at 2:05, and I have more to say.